Good day to you all. My name is David Dhumbura. I'm a second year law student at Africa University. My presentation is on the general test for relevance under the law of evidence. The objectives of my presentation are: one should be able to understand what is relevant, one should be able to understand the difference between relevance and admissibility, and one should be able to understand Section 252 of the Criminal Procedure and Evidence Act, which suggests that no irrelevant evidence should be submitted in the court, and one should be able to understand the basic factors that are used to determine relevance in court.
General test for relevance introduction. In a court of law, no evidence may be applied if it is irrelevant, and if it cannot prove or disapprove a point or fact at issue in proceedings. The test of relevance in the starting point consideration for the admissibility of evidence in proceedings. Irrelevant evidence is inadmissible. The relevant evidence is commonly admissible. The two essential values of relevance include the fact that nothing is to be received which is logically not verified regarding the matters which are required to be proved, unless and until the clear ground of law or policy is excluded. Everything which is verified or probative should come in. Relevance combines a statement of evidence and a statement that needs to be proved. However, it is essential for one to know that not all relevant evidence is necessary. Admissible, admissible as the rule is that any evidence which is relevant is admissible unless there is some other rule of evidence which excludes it. The rule of evidence govern what information is able to be placed before a court for determination of an issue. The court needs to make sure that there is a connection between the issue of the case and the evidence that is going to be admitted. This can be a matter of common sense, for example, in a case where one is being accused of burglary. The evidence would be clearly irrelevant. The rationale for the exclusion of irrelevant evidence include: number one, proof of unrelated facts won't assist the court because it has no probative value on the issue actually before the court. Times Number two, time, cost, and inconvenience. Number three, limitations of the human mind. Number four, the risk that issues may become clouded. Number five, the party against whom irrelevant evidence is adduced may be find themselves in a position where it will be difficult to defend themselves. Number six, constitutional guarantee to an accused for their rights to a fair trial. The meaning of relevance explains a situation where two things are related in such a way that proof of one proves the other. It is in the sine qua non or but fair test of admissibility, but it can't guarantee that evidence will be admitted. One should know that the relevance of evidence must not be easily elevated to a general principle. Stephen provides the following classification formulation. The word relevant means that any true fact to which it is applied are so related to each other that according to the common course of events, one either taken by itself or in connection with the other fact proves or renders probable the past, present or future existence of non-existence of the other. Rule 401 of the Federal Rules of Evidence of the United States of America defines relevant evidence as follows: evidence having a tendency to make the existence of any fact that is of consequence to the determination of action more probable or less probable than it would be without the evidence. The judges in courts have the duty of making accurate decisions when it comes to the test for relevance, as this helps to provide the court with a practical and utilization utilitarian tool to be used in looking through all the information which may possibly assist in providing a civil or criminal case in order to determine which of these informational facts should be admissible or inadmissible. Relevance cannot be determined in isolation, must be assessed by reviewing the totality of different combination of factual circumstances which create each individual case. This can be supported by case of S of State versus Zuma, in which Van der Merwe J suggests that the first question is always what are the issues. Relevance cannot be divorced from the dispute facts of a particular case before a court. This unique sets a factual circumstance vary on case by case basis of the concept of relevance cannot be easily reduced to a signal abstract legal theory. The meaning of relevance now begins to take shape fundamentally. Relevance is a question of fact and inferential logical and not a matter of law. The first step in any coherent relevance inquiry is to identify the substantive facts of the dispute before the court. Common sense detects that an item of evidence is selected to be a part of legal truth seeking process because it has a logical connection to a primary or even a secondary material fact in issue. Evidence which has a logical connection to an immaterial fact in issue in superfluous or irrelevant for the purpose of proving the material fact in issue. The second step in the relevance inquiry is to examine the nature of the relationship between an evidential fact and a material fact in issue. Stephen's influential definition of relevance as adopted in South African law by Arya versus Katz explains the relationship as the word relevant means that any two facts to which is applied are so related to each other that according to the common course of events, one either taken on its own or in connection with other facts proves or render probable the past, present, or future existence of none or non-existence of the other. We should also take into consideration the Zimbabwean Criminal Procedure and Evidence Act, Chapter 907, Section 252, which states that no evidence as to any fact, matter, or thing shall be admissible, which is irrelevant or immaterial and cannot conduce to prove or disapprove any point or fact at issue in the case which is being tried. The act was used in the case of Didmus Mtasa versus Ngwaninduna. The court looked at the application and suggested that according to the fourth respondent, the evidence of the applicant is necessary for the purpose of his defense in his prosecution before the magistrates court under section 3 of the Gazetted Lands Act. His defense in essence is that he is given an offer letter by the applicant which constitutes the requisite law authority entitling him to remain in the occupation of the farm without contravening section 3 of the Gazetted Lands Act. His evidence is that his offer letter was returned to the applicant in order to correct a spelling error in his name and that the letter was then never handed back to him. He now wants the applicant to testify on his behalf by confirming that the offer letter was in fact originally issued to him. The applicant challenges the propriety of his testimony on several grounds. In particular, he relies on the grounds of inadmissibility of evidence and non-compellability of witness as set out in Section 250 of the Criminal Procedure and Evidence Act, Chapter 907. This section provides as follows. Section 252. No evidence as to any fact, matter, or thing shall be admissible which is irrelevant or immaterial and cannot be conduced to prove or disapprove any point or fact at issue in the case which is being tried. This can be noted in the case of S versus Shabalala, 1989, which is a South African case. The decision was that although the principle on the admissibility of evidence regarding the behavior of tracking dogs was set in Arya versus Trupedo, 1920, the trial court in Shabalala had departed from this principle. The question is whether the court was justified in doing so. Firstly, the appellate division stated another principle, namely that the decision of the relevance of evidence should not normally be elevated to a general principle, since relevance would normally be affected by the facts of the case. However, when a court decides that certain legal consequences should follow from certain facts, this decision will be binding in subsequent cases in terms of the normal principle of the doctrine of the doctrine of precedent. Trupedo contains such a decision. Remember, the decision in Trupedo was a finding by the appellate division whose findings of the law are to be followed by all subordinate courts such as Supreme Court dealing with the trial of Shabalala. In DPP versus Kilburn, Lord Simon said evidence is relevant if it is logically probative or disapprobative of some matter which requires proof. I do not propose to analyze what is involved in logical probativeness, except to know that the term does not of itself express the element of experience which is so significant of its operation in law. The possible elsewhere it is sufficient to say that relevant evidence, i.e. logical probative or disapprobative evidence, is evidence which makes the matter which requires proof more or less probable. In Kane versus State, it was suggested that the standard of law expressed by the court was that the assurance of the determination of the particular thing of evidence lays on whether a verification of the evidence would be sensible in general assistance, settle the essential issue at trial. Now we go to the part where we try to show you the difference between relevance and admissibility. So there is a table here which compares relevance and admissibility. So we're going to start with relevance. At the point that certainties are so related as to render the presence of non-presence or of different facts likely as indicated by the normal course of occasions or human conduct, they are called relevancy. Then admissibility, at the point when facts have been announced to be lawfully significant, they become admissible. Then relevance, it is found on the basis of rational and human experience. Admissibility, it is established on law, not on the rational. Then relevance, it mainly emphasizes on what facts are necessary to prove before the court and not. Then admissibility, it is between relevance and proof. It facts as a decisive factor. Then relevance, it basically implies the relevant facts. Then admissibility, it is mainly focused on the facts are admissible and that facts are not admissible. Then relevance is basically a cause. Then admissibility is mainly an effect. Relevance, the court has the power to apply discretion in relevance. Then in admissibility, the discretion cannot be applied by the court in admissibility. Then relevance, admissible facts can be relevant. Then in admissibility, relevant facts are not admissible. Legal relevant facts are admissible. Then what is logical relevance? In terms of logical relevance, is determined by the connection between two assertions of legal reality. According to Wigmore, the, the weight of the inference to drawn from a first statement in what relevance reasoning concerned with and is based on inductive logical rather than deductive logical. As an illustration, consider the fact at issue in the legal dispute, thesis B as stated in the evidence supporting thesis A. The truth of thesis A is the tendency so as at the very least leads to a corroborate thesis B truth or to disapprove it, making thesis A significant to thesis B. The disposition of evaluator using a straightforward kind of probability theory. Relevance describes the logical connection between the two theorems. Materially might be seen as a crucial concern as well. An evidentiary fact is only pertinent in it can be rational connected to the relevant material facts. It is important to highlight that all admissible evidence must be materially evident, since an evidentiary fact that can only be logical connected to an immaterial fact in issue is relevant by definition. A piece of evidence is irrelevant because it cannot be logically connected to the relevant fact under the circumstance, or even though it can be possible, the substantive fact to which it is connected is not in dispute before the court. According to the following characteristics of a common law system of evidence, relevance during a trial in the test used to separate potential evidentiary facts from a mass of general irrelevant and pointless material. A particular evidential fact proposition A above must exist in a relationship with a substantive fact in issue. Then B, a particular evidential fact is relevant or has probative value when it has the tendency in logical to render the existence of substantive fact in issue more or less probable. The relevance of an evidential fact is also dependent on its relationship with a material fact in issue. The evidential fact in relationship with a material fact in issue only is by definition irrelevant. Then D, a logical relevant evidential fact with a high probative value may be excluded from trial by certain policy consideration. The admissibility or the inadmissibility of a logical relevant evidential fact with a marginal probative value is determined by weighing its probative value against an appropriate procedural rule of exclusion by way of cost benefit analysis. Then basic factors used in determining relevancy. Relevancy can be determined by the nature and existence of determining the issues in dispute. The risks of manufactured evidence must be taken into account. Precedent can determine the relevance of certain type of evidence, and a court shouldn't exclude harmless irrelevant evidence. In other verses and pans, it was suggested that relevant in from their existence inference may probably be drawn as the existence of effect in dispute. For one to decide whether a reasonable inference against eventually the possible, the court must create a provisional assessment of the potential weight of the evidence so to be cited. One must show an advance in indication that the received evidence will be valuable in assisting the court in the exercise of its duty of fact finding. Zuckerman explains where the relevance or irrelevance of evidence in the issue's potential probative weight must be assessed. His judge is, his judge is not concerned in to estimate the final weight of any piece of evidence at the admissibility stage. He is only concerned to make a rough and ready estimate of the potential contribution of that evidence in question make and whether it is substantial enough to justify admission. The admissibility test is therefore a composite test made of mesh of consideration of logical probabilities and of practical utility. On some occasions, the potential contribution of the evidence adduced will be immediately apparent. For example, the testimony of an eyewitness to the disputed event. At other times, its potential will only emerge from a juxtaposition of the evidence in question and another pieces of known facts. If upon the presentation of an individual piece of evidence the judge is in doubt about its relevance, you as the party offering it how it relates to the rest of the evidence he plans to adduce. If a publican claims that the brewer supplied him with the bad beer, then then the fact that the same brewer supplied another pub with bad beer might not be sufficient weight to be admissible, but it would become sufficient weight if it is also shown that it is one of five incidents of supply of bad beer by the same brewer in the same neighborhood within the space of a day. The courts initially review a potential weight of evidence is done for purposes of finding admissibility. In such evidence as may be admissible must ultimately at the end of the trial be reviewed in the light of all the other evidence purposes of determining sufficient, that is whether the required and applicable standard of proof is being retrieved. The then the next point is the issue as the essential point of departure can also be used in determining relevance and suggests that relevance cannot be decided in vacuum. This is supported by the case of S versus Zuma, where Van Merwe J said this question of relevance can never be divorced from the facts of a particular case before court. The nature and the extent of the factual and legal dispute must be considered. In Lloyd versus Pro Defense Team Co. and Ltd., it was said that that the very first question that must be asked in deciding admissibility is what are the issues. The term relevance finds concentrated application not only in the light of primary factor probanda but also the secondary factor probanda, the factor probancia, which are in dispute. In Arya versus Solomons, it was held that subject to consideration of prejudice, a ruling of the on the admissibility of evidence could at a later stage be reversed in the light of new factual issue which might come to light during the course of the trial. Decision of the admissibility of evidence are inter and may be therefore be, as Arya says, in the light of new facts. Direct evidence is another point, can also be used to determine relevance. Direct evidence provides direct proof of effect and it does not have any inference. This usually based on the eyewitness account determined to support the truth of an assertion directly. The problem with direct evidence arises when there is need of applying circumstantial evidence. Circumstantial evidence can be defined as indirect evidence and by contrast consists of a fact or a set of facts of, for example, this may lead to intervening inference that the matter says is true. However, circumstantial evidence does not directly prove that the accused is guilty of an offence. The principle of completeness. This it is also used to determine relevance. A court should not remove harmless, irrelevant evidence. A witness should be allowed to tell a coherent story and in so doing provide the court with general background to the disputed event. Reasonable inference can also be used to determine relevance. This type of evidence must have a reasonable inference to enable the court to come to a fair decision. In Arya versus Trudeau 1920, the accused was charged for contravening Section 6 of the Ordinance 26 1904 in that he entered a residence with the intention of committing an offence. Three persons were sleeping in a room in a hostel and one a girl woke up and when the accused stood on a bed and started screaming, which led to the accused leaving the room through a window. During the investigation, a police dog was used to follow the scent from the window through which the accused had escaped to another house where the accused and other people were sleeping. The dog sniffed at the accused and at the other people, but however went back to the accused and barked. The evidence of the behavior of the dog was tendered in order to prove the identity of the accused in the court. The trial court accepted the evidence that it was the accused unlawfully entered the room to commit a crime unknown to the prosecutor and was found guilty. On appeal, it was held that the evidence was inadmissible as no reasonable inference could be drawn of the action of the police dog towards the accused. In its J, the court held that by admitting the evidence of the police dog, it would be to enter a region of conjecture and uncertainty. However, the evidence was rejected. The inference caused by the dog's striking activity lay in the region of conjecture and uncertainty. The court considered that its perception would be dangerous because it might be inclined to give it an exaggerated importance on account of its dramatic and almost supernatural qualities. The law of evidence is concerned with the exceptions to the operation of the general principle. According to the Sock Dragger, the Tropedo decision should not be interpreted as a total prohibition concerning behavior of the police dog. The importance of the case is that evidence can be irrelevant even the ordinary man would be prepared to draw inference from it. Avoiding a proliferation of or multiplicity of collateral issues can be used in determining the relevance of evidence. The court has to investigate whether or not the admissible of evidence will lead to protracted investigation into many collateral issues or side issues in finding out the relevance of evidence which is investigated would have very little probative value concerning the true issue before the court. According to Van der Merwe, a proliferation of issues should be avoided. This often accounts for the exclusion of similar facts evidence. One can know that the relevance of evidence can be shown by the tendency to make a fact more or less probable that is that it would be without the evidence, or by the fact of consequence in determining the action. In as versus Neo Marais, J agreed with the trial court refers to an accused to lead a epistatic evidence. The purpose of this proposed evidence was to show that a defense witness who is a testimony had contradicted aspects of the accused testimony was mildly to moderate retarded and therefore likely to clamp up under the strain of testifying in court. So another example is the risk of manufactured evidence. It's also a source of determining relevance. It is made of statements of a witness are as, are as a rule excluded. One of the reasons which lead to the exclusion of such a statement is that the admission therefore would make it a very straightforward matter for the manufacturer evidence which is unacceptable. Accordingly, there is a general rule in the words of the Supreme Court of of appeal in S versus Scott Crossley that the previous consistent statement of the witness has no probative value, and it is an account of this no more lack of probative value that it is then said a previous consistent is relevant. There are certain established exceptions to the rule. It can be argued that where these exceptions apply, the risk of manufactured evidence is outweighed by the probative value of the previous consistent statement, thus rendering the otherwise irrelevant statement relevant and admissible. Another example is prejudicial effect can also be used in determining relevance. Evidence which is logically probative or disprobative can be excluded because of its prejudicial effect on the party concerned. Prejudice is in this context does not mean that the evidence must be excluded simply because the party against whom the evidence stands to be adduced will be incriminated or implicated. It means that incrimination or implication will take place in circumstances that where the party concerned may be procedurally disadvantaged or otherwise exposed to a lengthy trial involving issues which, though logically relevant, are legally too remote to assist the court in its ultimate decision of the merits. Evidence is relevant if its probative value outweighs its prejudicial effect. Proof of motive provides a good example. Then another good example is the doctrine of precedent. Can also be used in determining relevance. Judicial precedent can determine the relevance, admissibility, but not the final weight of certain types of evidence. In S versus Shabalala, the court came across the conclusion that the judgment of int CJ in Rex versus Trupedo did not rest solely on the factual finding concerning the reliability or otherwise of the particular dog whose activities and abilities were in issue, but was essentially rooted in the principle that evidence of conduct of the dogs in identifying an accused scent scent is inadmissible. However, Nestor J.A. did point out that if the untrustworthiness of such evidence could be sufficiently reduced, even though not totally removed, then actions of the dog would become relevant and evidence therefore admissible. It would seem that a cautious approach is necessary before boldly invoking judicial precedent to decide on admissibility where relevance is the issue. Facts differ from case to case, and precedent can therefore at most provide useful guidelines. Another example is constitutional imperatives and the position of the accused can also be used in determining relevance. It has been argued the defense such that the defense should have more liberals than the prosecution to adduce evidence which may not be of a special high probative value. This argument has some weight in constitutionalized systems such as ours, where an accused has a constitutionally guaranteed right to a fair trial, which includes the right to adduce and challenge evidence. However, the rule that the irrelevant evidence is inadmissible in most certainly a constitutionally permissible limitations of the right to adduce and challenge evidence. There, there cannot be an unqualified right to adduce irrelevant evidence or to challenge inadmissible evidence with irrelevant evidence. Such a right would make no sense. This is supported by the case of Rock versus Arkansas, a American case where the Supreme Court gave a decision based as it is an constitutional due process does not extend to the situation of the prosecution witness. In the case of the accused was charged with manslaughter of her husband. So now we have a brief discussion on civil cases in basically found in Zimbabwe. The Civil Evidence Act, Chapter 801, Section 26 says irrelevant evidence is inadmissible. The general rule in civil proceedings is that if evidence is relevant, it will be admissible unless it falls within the scope of an exclusionary rule prescribed in law or the court exercises its discretion to exclude it. It should be noted that the rules of evidence in civil proceedings have been relaxed over time. For example, if someone breaches a contract, the most essential, relevant, and direct part of the evidence is usually the contract. The contract highlights in the court the responsibility each party involved in the contract had. Therefore, one of the parties may also present testimony showing that the other party failed to make a payment or respect the terms of the contract that they had agreed on when the contract was made. All of this evidence is relevant as it highlights that one party failed to follow the terms of the contract. Hence, one can know that proving one party failed to stick by the terms of the contract is the effect or of consequence in adjudicating a breach of contract case. Then we have another discussion on excluding relevant evidence. When it comes to deciding either the relevant evidence can be presented should still be excluded, the court avoid discretion that certain pieces of evidence present by focusing on legal issues in the case because they are its main concern. One of the biggest dangers possibly outweigh the probative value of evidence, and a good example of this is unfair prejudice. It is common in the courts and leads to relevant evidence being excluded. For example, a robbery case where the prosecutor wants to invite a witness who saw the defendant give a testimony as they eyewitness the using of drugs by the defendant near the store that was robbed about 10 minutes prior to the robbery. Hence, one can know that the evidence is irrelevant because it reveals that the defendant was near the store during the time when the robbery happened. However, one can argue that this testimony probative value may be outweighed by the danger of unfair prejudice, as this testimony raises the risk of prejudice because it indicates that the defendant may have committed the crime of drug use and is a person who regularly commits crimes. A court may decide to put aside the testimony of the witness in order to prevent the risk of unfair prejudice to the defendant. The last example of the robbery reveals a special type of evidence referred to as character evidence. Character evidence can be used to define a character trait of a human being, such as prudeness to commit crime. Character evidence could also be used by a witness giving a testimony that a person in the case has a reputation in the community of being a violent, or a witness opinion that the defendant is very honest and well mannered. The general rule is that character evidence cannot be used to decide on the fact that a person acted in accordance with a character or a trait on a particular event or a day. Hence, one can note that if plaintiff wanted to present testimony indicating that the defendant is known as a violent person, this evidence would be of no use as a case to prove that the defendant actually acted violently on the day of the alleged assault. This type of evidence presents a threat of unfair prejudice because it leads the court to judge the defendant based on his reputation or reputation rather than on the facts established during a trial. One can note that the admissibility is a question of law. The court has a duty to assess depth, relevance, and persuasiveness of evidence being provided. The exclusionary rule was mentioned in Section 73 of the Constitution of Zimbabwe of 2013 is subsequently amended and suggests that evidence obtained in a manner that violates any right in the Declaration of Rights must be excluded if the admission of that evidence would render the trial unfair or otherwise be detrimental to the administration of justice or public interest. The exclusionary rule prevents the state of any party from using most evidence gathered in violation of relevant provisions of the Constitution or certain statutory provisions or a settled rule of practice or norm. Hence, one can know that the exclusionary rule applies also to evidence gained or obtained through an illegal or an unlawful or unreasonable search or seizure in violation of the settled standard and practical procedure. For example, under the doctrine, a court may decide to exclude from trial not only evidence that itself was obtained in violation of the previous order of the Constitution, but also any other evidence that is improperly obtained. Another scenario is when one might have committed murder but later is forced to confess to another crime. Hence, one can know that the purpose of the exclusionary rule is found in the Declaration of Rights, as it has the intention to protect citizens from illegal arrests, searches, and seizures. It was created to provide a solution such as reparations and disincentive for criminal prosecution from prosecutors and police who improperly gather evidence. In conclusion of my presentation, one can know that relevance is a test of admissibility. The court is the one which controls the admissibility of evidence in Section 252 of Criminal Procedure and Evidence Act, Chapter 907, and also the Civil Evidence Act, Chapter 801, Section 26. A variation is made among relevance and admissibility on the off on the off chance and that it is very well may be demonstrated that the evidence would be relevant whenever demonstrated. The court will consider proof of it. All admissible evidence is relevant, but all relevant evidence is not admissible. Any relevant truth is not tolerated in court, even if it may be in a specific case. Evidence which is not relevant under Section 252 in any case may not be acceptable. One should know that evidence is regarded as more essential in deciding cases over many years. The power given to the magistrates or judges in deciding whether evidence is admissible or not is immense and must be limited through rules. The law identifies evidence which is not reasonable for the present generation and must be changed for better working of legitimate framework. Yeah. So an important line is to be drawn between the intensity of the judge, all things considered a great power given to individuals who would just bring about development of intensity. The law is incomparable and no person must have the optional capacity to change it to his or her benefit. Every part of evidence which concerns the case must be admissible, whether it is found through illicit and or some other methods. There are many cases in which people have invaded the law because of inadmissible evidence. The general test of relevance tries to ensure that the courts are just and efficient when it comes to giving a judgment. Yeah, so thank you. This is the end of my presentation. I hope you find it helpful.